Okay. Hi, I'm Lucy Lee. Good morning and good afternoon and good evening to all of you. Thank you for joining us. So I am an immigration lawyer in San Francisco with 30 years of experience in this industry. And we are the oldest immigration law firm in San Francisco, formally established in 1925 with our first file dating back to 1911. And I enjoy what I do. We work with a lot of established companies, whether in the US or global multinational, investors, professionals, as you see, ranging from software engineers to dancers, all sorts of professionals. And we unite families and individuals, and we deal with citizenship. Thank you very much for having me. The next person we'd like to introduce to speak a little about herself is Ms. Chelsea Wang.
Hi, good morning and good afternoon, everyone. My name is Chelsea Wen. I'm the founder of the Oasis Law Group. I specialize in various type of laws in the immigration area, including family petition, employment-related petitions and visas, and also removal proceedings. So I work with both individuals and also business entrepreneurs. So I specialize in really tailor a customized legal solutions to your immigration problem. So it is a pleasure to join the seminar. Looking forward to working with you all.
Right, and we have Peter Drew.
Hello, everybody. It's Peter True. I'm a partner with Crow. We're a national accounting firm. I myself am in the Global Private Client Services group, and we focus on high net worth individuals, particularly those with international tax issues. My background as a trust and estates attorney helps me with the trust planning as well as the income tax planning, utilizing trust, whether they're foreign or domestic.
All right. Yanni, do I have control of the slides? Sorry, I'm trying to control it. Let's move up to the next PowerPoint, except I'm trying to advance it, and here we go. Sorry, the prompts don't always show up. So here's our general agenda for the day. Today, our purpose is to give you an overview. Many years ago when I was in law school, we called it issue spotting. And so our purpose here today is to give you an overview so that you have the ability to recognize when a particular situation may apply to whether it's your business associates, or your family members, or yourself, on when to call on a professional such as ourselves to consult with or to ask questions. Our purpose today is to give you this knowledge so that you can facilitate business and have commerce with companies all over the world and within the US. So in part one, we'll talk a little bit about different work visa options. We'll talk about, and integrate into that, we'll talk about startups, investors, companies, individuals, families, green cards, citizenship, and taxes. And Peter, at the end, he will talk about taxes and the implications for people on visas and green cards for applying for citizenship. Okay, let's move to the next slide. So I'm looking for the button. Yanni, can you move to the next slide, please? Not able to. There, thank you. So the first slide here is about L1 intracompany transferees. This is going to be the scenario where there is a company that's already established, usually somewhere outside of the US. Like say you have a company in China or Hong Kong, or Singapore, Taiwan, what have you. There's a company and they may or may not have an existing related entity in the US. And so, if they have a related entity, there's usually some qualifying relationship. If they don't have one, then usually people come and they look at possible locations, what kind of business they want to do. They do some market research, and they set up either a parent subsidiary relationship where the company abroad owns at least 51% of the US entity, or sometimes you have a US company that opens up a subsidiary abroad outside of the US. So sometimes US run companies say, hey, we want to open up a subsidiary in China, or Hong Kong. And so that becomes a subsidiary. Sometimes you have multiple shareholders or owners of a company. And, they want to hold them as affiliates, where it's like brother sister company, and both entities have the same set of parents, basically, but each shareholder owns the same percentage of stock in the two entities. At times, there are companies that have, they have offices all over the world, and that would also suffice for an L1A. The beauty of an L1A is that it gives a lot of flexibility for people to come and do business. It has to be an active business, meaning you can't just park your money and do nothing with it and grow it. It means that if a company is being set up, the most common scenario is a company outside of the US setting up an entity here. They need to incorporate, have an actual, location. They need to hire, they need to start bank accounts. You need to hire, at least a business attorney, have a CPA. You need to have all these things and intend to hire employees and be imminently ready to do business. And the money invested has to correlate with the kind of business that they're doing. So you have a business that's going to be, say, manufacturing semiconductor equipment. It's got to be substantial investment. 100,000 is going to be nothing. I mean, it's going to be like hundreds of thousands, if not millions of dollars. Sometimes people ask, well, how much can I invest to start a company? It depends on your business, the kind of business. If you're going to be importing, exporting fake plastic flowers, the investment will be less than manufacturing tech equipment. If you're investing to start a business in California, in the Bay Area, you will require more money because rent will be higher and salaries will be higher. Whereas if you compare and you invest in the middle of Ohio, Wyoming, that amount would be substantially less because the cost of business is less. For an L1, it does matter the size of the company. There's all different sizes of companies. We usually advise if the company is too small. Being too big is never a problem. It's when they're smaller, we want to see, look, how many employees do you have? How big are you? What kind of people are in your company? So we can see if they qualify for an L1 and then tell them what needs to be done in order to have an L1. Sometimes companies are not ripe for an L1 status. I tell them, look, you need to hire some more people in your company abroad. Or if they don't need that many employees, they have to explain why. How does their business model affect this? I usually ask for a 5-year business plan to explain to the government so we can submit that with an application of how they're going to conduct business and what kind of jobs are they're going to be growing and what kind of an investment. Who qualifies? People who are executives and managers. And one of the other things besides the actual business and and investing money is that these individuals who would be transferring over have to work at least 1 year full-time status, continue in the company abroad outside the US for at least 1 year before they qualify to come to the US. You have to be on payroll. So if you have a company outside that's too new, I tell them, or the person joined not long ago, I tell them just wait or send someone else, have them work there for a year before they qualify to come here. So you have the company qualification and the ownership, you have the individual, you have managers and executives. So you need to manage other people who are either professionals or supervisory people, or manage a function that could be like a project worth lots of money. Specialized knowledge applies to people who have, some proprietary knowledge that this company has that no one else has. And they're coming to the US to share that information, to bring it over here so that the US company knows how to use that and to train US workers how to use this information. Typically, the L, specialized knowledge, is good for up to 5 years. The Immigration Service is not going to give you 5 years up front. They'll give you 2 or 3 years at a time. And managers and executives get upwards of 7 years. And again, to give you a few years at a time. If it's a startup company, you get 1 year up front and it's extendable. Let's move to the next slide. So the US has treaties with various countries around the world. And here you see a bunch of alphabets, E2, E3, H1B1, and TNs. The next slide. So this is in a nutshell. So in terms of E1, E2s, if you look up or Google, treaty countries or US Department of State, treaties, there's going to be like a long list of countries we have treaties with. And these are treaties of navigation, friendship, and commerce that the United States has with countries around the world. Some countries fall under E1 and E2, some fall under just one or the other. For example, we have a treaty with Singapore, we have a treaty with Japan, we have a treaty with Taiwan, Canada, Mexico, most European countries. So, we always look to see if there's a treaty. The reason why is if an individual or a company says, we're going to invest a certain amount of money, or we're engaged in export-import, I'm going to look to the treaty for some flexibility. Why? Sometimes they may not have a company outside the country to do an L1 to transfer them. It might be someone saying, you know what, I left my old job and I have a boatload of money. I'm going to invest and start a company in the US. I'm like, good for you. Let's see what country you're a citizen of. The treaties go by country of citizenship, not country of birth. So I always ask people, do you have more than one citizenship in different countries? You can have dual or triple citizenship depending on what the countries allow. E1 has to do with substantial trade. So in this instance, there would be a company in the country outside the US, and there would be an existing company where that company and the US does more than 51% of its import-export between those two countries, and it's got to be substantial trade. Substantial, there's no dollar sign. Sometimes it's based on volume. If you're importing, exporting, say, high-tech equipment, that's going to be based on a really high value. You're importing, exporting rubber gloves, say used for surgery, that's going to be based on volume because rubber gloves don't cost as much as these, high-tech equipment. And then and again, you have to maintain that level of trade for import, export all the time. For the E2, in comparison, it could be any kind of business. It doesn't have to be import, export. Someone can invest, into a business here from any country, and they could start up a filmmaking business. They could start up a restaurant. They could do many things under an E2, but the investment has to be enough. And again, we have to show a 5-year business plan so that the US consulate or embassy that grants this visa will believe it. And it has to be enough of an investment. I tell people, don't make it all the money you have in the world, because the officer might ask, do you have any other capital or money in case this is not enough to carry the business? And the business needs to be owned at least 50% by someone who's a citizen of the treaty country. So there's a lot of strategy between when we pick between, what different kinds of visas and what are the limitations and what's the flexibility. The beauty of the e-visas is they're renewable indefinitely. I have some clients that have e-visas for like 15, 20 years, because guess what? They don't want to stay here. They come in and out for business. They're very global and they don't want to get green cards. And typically it's for some kind of tax reason, which Peter can talk more about later on. Australia has its own treaty with us for E3s. These are for professionals who have a bachelor's degree in some specialty occupation. So I know that oftentimes we have just Australians, or sometimes we have people from other countries who have citizenship in Australia. And that's always an option too, for someone to come over here. We have a treaty with Singapore and Chile. It seems odd that we have one treaty that covers those two countries because they are so different from each other. But this one treaty, the H1B one, applies to Singaporeans and Chileans. And again, they're for professionals with bachelor's degree, and they can come over here and work. It's an option if they have this particular country's citizenship. Last under the treaties that I'll talk about is TN. So we have the North America Free Trade Agreement between Canada and Mexico. It's called NAFTA. They allow professionals into the US. There is a very specific list of occupations, everyone from engineers to veterinarians, to come in here and to do work pursuant to that treaty. Canadians apply at the port of entry at the border, and Mexicans have to pick up a visa at a US consulate before they get into the country. And these are renewable as needed. Let's go to, and these are visas that have temporary intentions, meaning they're for a very limited period of time. Chelsea, why don't you talk about H-1Bs?
Sure, yeah. So the H-1B visa category really applies to non-citizens who who will work in the United States in something called specialty occupation. Actually, could you move to the next slide, Lucy? Yeah. So what does specialty occupation means? It really applies to this visa, applies to people who are highly skilled professionals. For example, accountants, engineers, pharmacists, scientists, and teachers who have specialized knowledge and skills. And generally speaking, to qualify under a specialty occupation, it does require either a US bachelor degree or the equivalent in a specific field, or in this case, for the foreign national, could also have an equivalent degree or relevant degree overseas. So for H-1B, this type of visa, generally, so there's something called the fiscal year. So for the US Immigration Services, the fiscal year generally runs from October 1st of the year to September 30th, which is different than our regular calendar years. So during that fiscal year, the USCIS allots a certain numbers available for this visa category. So the base number is 65,000. That is for new H-1Bs each fiscal year. Plus, there's also an additional 20,000 for US masters or a higher degree graduates. So that gives a total of 85,000. So there's also 6,800 for applicants from Chile and Singapore. Those are under the free trade agreements. So generally speaking, this H-1B is a highly sought after visa because of the demand, the high demand in US for highly skilled professionals. The process recently has been changed. I think you probably have heard about the lottery system. In the past, that it used to be the entire H-1B quota will be exhausted before even the end of the fiscal year. So there leads to various attempts to try to allot the visas fairly. So in the past, that they require the whole application to be filed, and then they will conduct this random lottery to allocate the visa. But recently, in 2000, USCIS had changed the process. So currently, the process is the employer will go through a electronic registration process. And then once the employer goes through the registration, then they will be able to kind of enter the lottery ahead of time. So instead of preparing the whole application and wait if you get selected for your candidate, now you actually don't need to do that. If your candidate is selected during the lottery, then you will have 90 days to prepare the application. So in this process, it's more streamlined, it's more efficient. Technically speaking, it's less work for the employer because they don't have to go extensively into the application, not knowing whether the process can be, whether the applicant can actually be selected or not. And some of the key features for the H-1B visa is has a 6-year maximum. There are some exceptions of kind of extending that, which is more of a detailed question. Again, what we're trying to discuss in this seminar is more of a general outlook on this on the type of visas. And if you have specific situations, we would love to talk to you to see how we can structure the type of visa that tailor to your needs or your company needs. Okay, so in terms of the key features for the H-1Bs, one of the benefits is the dependent family members, which in this case will be spouses and children under 21. They're eligible to accompany the H-1B worker under H-4 visa. And then certain H-4 visas can also apply for work authorization. And the other feature that is helpful to know is, the H-1B visa can be approved only based on specific employer. So offering specific job at a specific location. So if you need to change, let's just say and a question that pops up a lot is, sometime, you are under H-1B visa, you wanted to change employers in the middle of the term. Technically speaking, we talk about an H-1B transfer, but it's really your new employer will need to file a brand new petition because it's no longer the same job at the same location that you had with a prior employer. Also, the other key features of H-1B is there is a requirement for H-1B employer to pay the prevailing wages or the higher the actual wage that's being paid. So your attorney, the immigration attorney, will need to do analysis with the employer to determine, let's say we need to compare both the actual wage and how is that compared to the prevailing wage. So this is the detailed analysis. The general attorney will work with the employer on that. The other question that kind of pops up is if a H-1B employment ends, the employer must notify the U.S. Immigration Services, have the petition revoked. Because as long as the H-1B petition remains in effect, then the employer is required to pay the worker's wages. Okay, so in terms of the process, we'll do analysis first on the qualification of the candidate, whether he has a prerequisite degree requirement or the equivalent. Also, we need to kind of analyze the position that has this demand for H-1B worker. And then the other components will analyze the wage requirement. How is a company, if the company has other H-1B employees to kind of compare the actual wages. So there's various aspects that we'll look into in this process. And also we need to closely monitor a lot of changes that are going through this process. There has been talk about, instead of the random lottery, we'll do a wage level based lottery, which is currently not in place for the fiscal year of 2023. But those are the issues that can come up that could change the strategies for the employer to hire H-1B employee. So those are the questions we'll go in detail once we do a consultation with employer or employee and analyze accordingly. So Lucy, you can go to the next slide. So yeah, so this is
myself.
Okay. Yeah, so this is what I kind of went through earlier. So about the requirement for specialty occupation primarily is an educational degree requirement. And I discussed briefly about the CAP requirement and also the process. Currently, it is the employer need to do a registration, and then you will have the opportunity to submit the application if the candidate gets selected. There are also multiple lotteries that's going on. So, generally, I think the chances of your application gets selected maybe 1 to 1, 1 to 2, or 1 out of 3. So generally speaking, yeah. So we can move to the next slide, Lucy.
Okay, great. The next slide has to do with people with extraordinary ability. So these are rock stars. And the trick is, what if it's deciphering between the rising stars and the people who have extraordinary ability. So let's get a little bit into that. Let's go to the next slide, Yanni. All right, so this is going to be a scenario where you have somebody, usually they have a degree, all right? And these are individuals. They're coming to work for an entity here. And the entity here could be a US-based company usually, or it may be a situation where the company might also be a startup. It could be a lot of different scenarios. But the thing about the O1 is that you don't need to go through a lottery. The H-1B is the only visa that needs to go through a lottery. So with the timing issues and projects, people oftentimes say, well, do you have other options besides the H-1B? We'll get into the lottery, but we don't know if you get picked. Let's talk about other options, so it becomes alphabet soup. So extraordinary ability, it fits people who are at the top of their field, whether they're in the sciences, education, athletics, entertainment. These are people who are the cream of the crop. And how do you define that? Now, if someone comes to me and says, hey, Lucy, I have like a bunch of publications. I'm like, okay, how many do you have? I have 5. I'm like, publish. I'm like, are you the author? Yeah. Did anyone collaborate with you? Yeah, I'm like number 3 or 4 on the list. You know, I'm not the first name. Do you have any awards? Do you have anything else? They're like, no. I'm like, okay, you don't qualify for an O1. So, and people like to say, well, my friend told me, my friend got it. I'm like, well, I would hesitate. You know, I would say, okay, well, maybe your friend can do your O1 for you. But we like to assess these. This is a lot of work, and it's a very thick packet. You know, usually at least, you know, 3 or 4 inches that we submit to the government, you know, to show that the person's extraordinary. Let me dig in a little bit. So in terms of if someone has awards and achievements, whether they're national, international, in different countries, what the Immigration Service wants to know is who chose you for that award? How did you get nominated? Or does everyone get it? Do you buy it? Or does anyone who applied get it? What's the selection process? How many of these awards are given a year? What's the significance of the award? What does it mean? What does it mean in that field to get this accolade, to get this achievement? It doesn't count if the person got the awards as part of school or as part of a degree, because then that's double dipping. It has to be something outside of school in the workforce. And it has to be in their field. Publications. Individuals could have been the author to write about something, or they could be quoted and cited. We also look at how many citations, or do people say things about them? Are there reviews? Are there articles? Are they in journals? So it goes very wide. And the government also wants to know, how did you get selected? Who reads this? What is the significance? What's the circulation? So they get into a lot of details on this. Now, for industry and scientific original contributions, doesn't have to just be in the sciences. It could be a bunch of stuff. There was someone a while ago who, to give an example, it had to do with a certain software that he developed for how to manage businesses and share resources in different companies across the board. So it saves you money, you become more efficient. And if you put his name in on Google, his name came up like multiple pages. He was just so good at what he did. Scientific, that's a little bit more common for people in a know. You know, again, it's someone who, oh, my screen just went blank. Okay, there it goes. For example, just to give you an example, someone who's a pharmacologist came to me a while ago, got her O1 and a green card based on that. And, you know, she had discovered the ability how to tailor medicine to each person's individual physiological makeup so you would recover and heal more effectively and efficiently. And she speaks all over the world. Now that's a rock star. That's someone we want in this country. Then you have people in the entertainment, you know, who entertain, and they're like with big groups, whether they're ballet dancers, entertainers, singers, create music. I had someone who, you know, was in, you know, the Hall of Rock and Roll. I mean, it was somebody who made a huge contribution. Not everyone achieves a high salary. I can count the number of times on one hand, maybe because I don't deal with Hollywood type people who get high salaries. And if they earn that much in their home country, they really wouldn't want to be coming to the US to begin with. They would come in just temporarily. It's more common that, you know, there are memberships that, you know, that are very prestigious, that they have to be invited to join and to be at the top of the field to be a part of. So that's extraordinary ability. And this is just an option, you know, to put out there for people who have experience, or sometimes if you're young, they could qualify because they start their careers young. Artists do that. Let's go to the next slide. Oh, Yanni. Okay, great. Okay, so Chelsea's going to talk. I'll give you an overview, and then Chelsea will talk about family base. So we're going to move. We're going to gravitate toward permanent residents, lawful permanent residents, also called green cards. That's the common term we'll just use, as everyone knows it. Even though the green cards are not green anymore, they're different colors now. So the visas that Chelsea and I talked about, they're temporary work visas. They're here to keep people for a limited duration of time. And if people choose for whatever reason that they want a green card, whether it's to give them the flexibility and ability to come in and out of the US as needed for business or for family, or they just want to be here. Maybe their kids want their kids to go to school here, or they continue to come in and out, just a variety of reasons. So we're going to talk generally about the family-based. W. Chelsea, I'll cover some employment-based stuff. And we'll just talk a little bit about other. Chelsea will talk a little bit more about that. So let's move to the next slide. And I think that'll be Chelsea, you're up.
Yeah, so for family-based green card, this is also very highly being used, especially when you have family members overseas once you become either a green card holder or a US citizen. So the benefits, if you are a US citizen and you have family members overseas, you have the ability to bring more distinct relatives than a green card holder can. So that, for example, your parents and your brother and sisters. So generally speaking, when you consider petition a family member to the United States, the first thing we wanted to qualify is what is the relative's relationship to you? And so the amount of time it takes for you to petition over here really depends on the relationship you have with the family member. If they're considered immediate relative, which are if you have U.S. citizen spouse, if you're a spouse to a U.S. citizen, or if you have children that are under 21, so they're unmarried children, right, of U.S. citizens that are under age of 21, or if you have the parents of U.S. citizen, if the U.S. citizen child is 21 years older. So let's say someone who is 21 years old and he or she wants to petition their parents come over, that will be considered immediate relative. The benefit of being an immediate relative, so there's really no waiting time. So there's no, a long wait for the family member to come here to waiting for a visa available for that family member. So that will be considered the best scenario for you. And if you have other family members that are a little bit more distant, there are different categories which are listed as preferences for them to. So there's a visa bulletin that's updated on a regular basis monthly that provides the most current date for the visa category for your family member. So in this chart, if you see that there is the first preference, second, third, and the fourth. So this is the first row is applying to family members of the U.S. citizens. So the first category would be unmarried children, any age. So generally speaking, this should be over 21 years old or older of a U.S. citizen. So they have the first preference. And the second preference is generally divided into two categories. The first one is for spouses and unmarried children. So here the children we're talking about is under 21 years old of a green card holder, okay? And then the 2B, hopefully you could see it's a little darker, and the 2B is for unmarried children, sons and daughters of green card holders who are already 21 years old or older. So the second preference category is mostly for family members of green card holders that are currently in US. And the third category will be considered for married children of a US citizen at any age. Then the fourth category will be considered sisters and brothers of a US citizen where the US citizen is at least 21 years old. So by having this different categories, when you are considered bringing a family member, you might want to have an attorney to assist you to look at, if I were to petition my brother or sister, or if I were to petition my married children, how long is the wait? So when the attorney help you to file a green card petition, generally there will be a receipt date, or it's also considered a receipt date, which is a day the applications are received by USCIS, is also considered a priority date. That is a date that's used as a reference when we determine how long approximately be the wait for the family member's green card petition will be approved or get a chance to be evaluated and reviewed by USCIS. And that is a very important question, especially if you have family members that are elderly, or the petitioner who's either the US citizen or the green card holder is elderly. So those are issues you need to look into. Sometimes I got questions where like a family member or US citizen, petitioner here in US is gonna go through a surgery or a transplant, and they will like their sister to come here to take care of them, and they wanted to apply a green card for that family member. But if the surgery is happening in 6 months in 2022, it would be difficult for her sister to come here in order to help her and take care of her. So generally speaking, when we look at those issues, the most important we're looking for is what is the petitioner, or in this case, the family member would like to accomplish. If the goal is to meet certain objective, like in this case, take care of the family member in US, how can we make that happen? So these are the kind of analysis generally the attorney will kind of go over with you and to choose the best option given the circumstances for your particular case. So the best practice will for you to bring up the kind of issues that you think are very important for your case and have the attorney to help you to analyze the situation and to determine if this is the best route for you and your family member. The other issues that I would like to kind of bring up is, if you have the green card, you also need to be careful that not to misusing any way, because which in another slide, we're going to talk about maintaining the green card, because if you don't properly maintain the green card, there will be various issues and it could be taken away. So those are things we would like to flag you in a later discussion today. Next slide.
Okay, next I'll talk a little bit about employment-based green cards. So you just heard the track that Chelsea gave you about family-based green card preferences. And, when we strategize, we get into the nitty-gritty of, it's not just someone's job or their family. We ask them, oh, tell me, do you have family? Who's here? Who is they might have a qualifying relative to petition for them. Or if we do a family case, we ask, well, what kind of work do you do? We want to see what's the most effective and fastest way to get somebody permanent residence here in the US. And sometimes there are two different ways going at the same time to see what's faster and what's more effective, especially because quotas change, processing times change, and laws change all the time. For employment-based green cards, you're generally going to look at 5 categories. And this is on a parallel track to having a temporary work visa. So the first preference is going to be like the people who have L1, the intracompany transferees. They're the multinational managers and executives. And you're going to have that. The people who have O1, who have extraordinary ability. The first preference means, and the US Department of State is the gatekeeper of the quota for green cards. They're called priority dates. And the concept is like, if you go to a bakery, you take a number to stand in line. When they call your number, it's your turn to get served. That's the same concept here for priority date and the quota for a green card. You start the process, you submit an application, Department of State says, oh, here's your priority date, it's your number to stand in line. And then based on your country of birth and what category you fall into in these 5 for a green card, it's your turn to get served and get the green card. It's similar for the family base. That's a different chart also with Department of State. So the first preference, typically it's a faster route because there are fewer people that qualify for the first preference. Multinational managers, executives, extraordinary ability, those are the O's, outstanding researchers and professors. And so sometimes outstanding researchers could be someone who was an O or an H-1B. Professors sometimes have H-1B, or if they work for a university, usually sometimes they're exempt from the quota that has the lottery. And for outstanding researchers, it has to be a place where they have other researchers. This is not the only one to qualify. And then we look to see what are your achievements? What are your capabilities? Why are you outstanding? Similar to the O. For a professor, they have to be tenure track. So it can't be someone saying, oh, it can't be someone saying, I just started teaching. I teach at a junior college, not to knock JCs. JCs are great, but you need to be tenure track at a university, okay? And it takes at least a few years to get to that point. Second preference is divided up where part of it requires to go through the US Department of Labor. That's the same with third preference. Third preference, they all go through US Department of Labor. Second preference, some of them do. So when we have to go through US Department of Labor, we have to do something called a perm labor certification, which I won't get into details today, but it takes about a year's worth of time. And that's where the employer has to test the labor market to show no one is taking away a job from a US worker. So if you have someone with a master's degree and a little experience, or a bachelor's and 5 years of experience, they're gonna have to go through Department of Labor. If they have some kind of exceptional ability or something where there's a skill set where we have a shortage, like nurses, you can bypass Department of Labor, but we have to, show why they're exceptional or why there is a shortage for that occupation and argue that with immigration. National interest waiver is going to be somebody who is doing some kind of work, what is in our nation's interest, education-wise, business-wise. It could be healthcare, it could be energy, it could be anything in our nation's interest to keep this person. And we want to look at the person's, accomplishments, their accolades. They don't necessarily have to be O1 caliber. Some of them are extraordinary ability. It's usually going to be something where it may be a better fit because they might not have all the supporting documentation that somebody who's an outstanding ability person may have, but they do something really worthwhile that's worth to keep this person here. It could be somebody who has figured out a way to save electricity and energy more efficiently with a certain thing that they have knowledge in. It could be someone who's developing, developing a cure for an illness. So that's also a way to bypass Department of Labor if you have a national interest waiver case. Their preference is actually one of the more common categories where you have somebody who has at least a bachelor's degree, okay, with maybe a little experience. Skilled worker is going to be somebody with in a position that requires at least 2 years of training. And we reference a lot to the US Department of Labor. They have reference materials. Did you know that foreign specialty cuisine chefs require 2 years of experience per US Department of Labor? So if you have a sushi chef or a Chinese cuisine chef, I mean, somebody, that a business here is looking to sponsor for a green card, they fall into the skilled workers, okay? Other workers could be other people, could be nannies, it could be, I had someone that built obstacle courses for equestrians, for horses. It's like the other category. I think our firm has done feng shui masters too, for a third preference for a green card. I mean, it runs really wide. Why do some people try to choose second or third preference over the other? Of course, it fits with what does the employer normally require for the position to sponsor for a green card, because you don't want to discriminate and get in trouble with the government. The other thing is, what does the person have under their belt to qualify, okay, outside of the experience with this employer? And we look at the country of birth for the individual. There's a huge backlog for people born in India and China, because there's so many smart people that want to come to the US and don't want to work here, that there is the quotas backlog. So oftentimes people will say, well, is there a way to get me here faster? Can I do a third preference? Oh, can I now get a second preference because I have a master's degree now? Oh, can I have both? And it's possible to have both second and third to see which one goes faster. Oh, guess what? I have some accolades now. Maybe I can qualify for first preference to get my green card faster. At the same time, someone might say, oh, you know what? I married a US citizen. So that goes to the family part, and then we can get them a green card that way. So there's a lot of mixing and matching and a lot of strategy that goes into the timing and someone's background. Sometimes spouses, you might have a pair, a married couple, where they're both on work visas and they both have green card cases going at the same time with their respective employers. And we will encourage them, both of you do it to see who's can go through faster. Because then whoever goes through faster, you can attach the spouse and any minor children, if the children are not born in the US, as dependents, derivative dependents, to see which one you can get the green card faster. You can even have 2 green card applications going at the same time, and you just withdraw, the one that's slower at the interview or when they get the green card the last stage. Now, there's an earlier slide where I made a blurb about cross-chargeability. What is that? So it's good to ask and to find out if the individual is married or about to be married. If the spouse is not a US citizen, not a green card holder, and they also have, say, a work visa or some other status, we ask them, what country is your spouse born in? Because guess what? I told you that the countries of India and China have the greatest backlog. If they're married to somebody born in some other country, we can do cross-chargeability to the spouse's place of birth. It is the coolest trick. And you can get their green card faster based on the spouse. You better be really nice to their spouse. So if you have someone born in China and the wait's like 10 years, I kid you not, and the spouse is, say, from Hong Kong or from Singapore or Malaysia, what have you, we can use the spouse's country of birth and we can bump it up faster because that quota could be available earlier. Fourth preference, we also do religious workers. These are, there is a work visa called R1s, which I'm not going to go into because I don't think a lot of you, have to deal with religious workers. But I want to touch on this because these are ministers, priests, monks, nuns, religious school teachers, cantors. There is a subcategory for this, for religious workers. And, they do have to qualify. For example, the ministers usually and the monks usually have to be ordained. They have to have worked with the organization for, at least a couple of years. So there is a qualifying factor for that. For fifth preference, Chelsea is going to talk about that. Let's move to the next slide.
Yeah, hi everyone. So EB5 is a very complex area. So given the time we have, I'll try my best to go a little quickly. So if there's any questions about this, certainly feel free to reach out to me, individually. So the EB5 investor program, it was created in 1990. And the purpose really to try to draw foreign investment capitals into the United States. So this is really a program to create that incentive. So when the program was originally created, the standard amount of investment required by law was standard $1 million. But if the investment is in something called a targeted employment area, which is designated, then the required amount for investment per investor will be reduced to $500,000. So there are two very important. Under EB5 investment, there are two different kind of EB5 programs. There's one called, you can call a direct job program or a standalone, which is the one basically you invest directly into a business. So it's a direct job program. The other one is considered something called a regional center program. This one is basically it's the one that the regional center has a project, and then you as an investor will invest into the project that are under a regional center program. And in that particular program, you are not actually hiring, creating the jobs directly through the direct investment into a business, but you are indirectly creating jobs through the regional center program. So those are two different kind of programs. The regional center program was something considered a pilot program for 5 years in 1992, and it has been continually extended. And this program, basically, I explained earlier, you can have both direct jobs and indirect jobs, so creating through the investment. So for EB5 program, it was very popular, prior to the changes that are happening recently, especially with Chinese investors. And I want to cover some of the basics, but it's too lengthy for this seminar. So the basic requirements, you need to invest, all EB5 investor must invest into a new commercial enterprises. And there's a specific definition on what it means in new commercial enterprises, and there are different ways to structure that. And the other component very important is a job creation requirement. What this requirement means is if you invest in a business or enterprise that is not within a regional center program, the business must directly create full-time positions to be counted. So, and the full-time position be counted has to be for at least 10 qualifying employees. But if you invest into a regional center program, then the program, the enterprise that's under the regional center program can directly or indirectly create a full-time position. So what that means is if you invest into a regional center program, let's just say a creation of a new enterprise that's a multi-function business center with condo apartments on top. The regional center will hire construction companies, architect company, various companies to put this project together. In that particular scenario, a lot of the jobs created through the regional center, created through the cascade of various so-called vendors or other business that partner with a regional center to make that project become viable. So that is the difference between these two programs. However, there is a recent change that really having a big impact to the EB-5 investor program. And this is regarding to, on July 29 of 2019, so there is a proposal basically to increase the standard investment thresholds from $1 million to $1.8 million. And then the reduced threshold, which is for the targeted employment area, generally is a rural area or in an area that has at least high unemployment rates. So the increase to 1.8 and also to 900,000 is a steep increase to what originally the program created, which is 1.5 million and 500,000. And however, the good news is that there is a case on June 22nd of 2021. Basically, the U.S. District Court for the Northern District, California, held that there was a procedural defect in that ruling 2019, that regulation. So therefore, the increase in the investment amount is not was not legal. So as of today, that the capital investment amount has been reverted back to the original, which is 1,500,000. The problems right now is the regional center program currently is not extended. So what that means is if any investor looking into investing in EB-5, they will need to invest in a direct job program, which is a direct investment into a new commercial enterprises. That means you need to create, each investor need to create 10 full-time employees or 10 jobs, right, for full-time employees for this particular scenario. So right now, really, we're looking to see what will happen to the regional center program. Is it going to get reintroduced again, or what's going to happen? We don't know. There's also talks of possible increase in the capital investment amounts. So those are things we're closely looking into. Certainly, if anyone interested in this area, they should definitely consult with attorney to get the latest updates on the situation. Next slide. So EB-6 Parole for entrepreneur. This program is not probably as popular as the EB-5 because EB-5 gave you the opportunity to lead to a green card through the investment, whether it's $1 million or $500,000. And however, the EB-6 Parole is not a visa that leads to green card. So that's an important point. It's really that you get granted a parole status for up to 30 months, for 30 months for qualified entrepreneurs to enter the US to work for a startup employment, okay? And you have the opportunity to extend an additional period of 30 months, but however, this is not a track to the green cards. And for this particular parolee, that so it's alternative methods for entrepreneurs who wants to come to US and remain here for startup employment and to kind of really work here, but not necessarily concerned about getting a green card. So that's something that it's important to pay attention to. In terms of terms, the maximum for EB-6 parolee is is 30 months plus 30 months. So it's 5 years maximum. And the requirements for this program, there's a lot of details and basics, but basically it cannot just be a passive investment where you really don't want to work on the startup and you just have somebody else run the business US. It does require a substantial ownership interest in the US startup entity, and you also need to have a central role in the business operation. So this is kind of similar to the EB-5, where if you do a direct job program, you do need to be actively involved in the business, versus if you participate, invest as an investor into a regional center program, you don't need, you could be a passive investor. So in this particular parolee, you do need to be an active in the business you're working on, which is a startup entity. So for this particular parolee, what's considered a startup entity will be a business that was created within 5 years immediately prior to your filing of the initial parolee request. That's what's considered a startup entity. The basic requirement for initial parolee requests is the business, you need to demonstrate by granting the parole, you're going to provide a significant public benefit to the US based on your role as an entrepreneur of a US business. So what that means is entrepreneur can meet the standard by showing that the US startup entity has received at least $250,000 from one or more qualified investors within 18 months immediately before filing the parolee application, or receive at least $100,000 through qualified government awards or grants within the 18 months prior to filing the initial parolee. So this is a very specific requirement that require documentations to show that. And if you continue beyond the 30 months and you can request for re-parolee. At that time, when you apply for re-parolee, then the requirements is different than the initial. It will require at least $500,000 in qualifying investments, and it could be from investors, or it could be from a qualified government grants or awards. So it could be a combination of both. And that's happened during the initial parole period. So you need to prove that you got a combination of either one of $500,000 during the initial parolee period. And you also need to create at least 5 full-time jobs filled for at least 1 year by a qualifying employee. And there's also another requirement that there has to be at least $500,000 in the annual revenue in the US for your business. So the requirements are very specific. So for the EB-6 parolees, that the spouse and the children, the entrepreneur can enter the US as a family member's derivative. They do have to apply for a separate application. So if anyone interested to us, please feel free to talk to us. Next slide. So for a green card maintenance, I kind of touched on this very briefly earlier. Once you're granted a green card, it doesn't mean that it give you the role to not to take care the green card, because there will be consequences for not taking care of the green card. For example, if you if you travel outside the US for more than 6 months at a time or more than a year, there is a presumption that you no longer consider US as your permanent residence. The goal is not necessarily just the time, because there might be situations that would require you to be outside the country for longer, but the issue is your intent. So how you can prove the reason why you're outside the country. Do you have the intention to abandon the US residence? What also matters is your physical presence in the US. How long are you generally been staying in the country? Do you have ties in US that shows that you have never abandoned US as your primary residence? So there's quite a bit of analysis that goes into it. We'll look at different factors. If you have particular situation that needs to be addressed, a family member illness or other situations that pops up, we can deal with those things, but there are some presumptions that built into this that needs to be dealt with attorney. On the other aspects of violations of law, so while you're being a green card holder, if you committed any crime, that potentially could affect your green cards. It doesn't just mean serious crime. It could be different kind of crimes that you might not consider serious or major crime, but that still can affect that have on your green card. So those are the issues the attorney can help you to analyze. Next slide. Okay, so naturalization. So generally speaking, for naturalization, which is applying for citizenship, generally speaking, that the general rule is you need to have a lawful permanent resident status for at least 5 years, but there are exceptions to it. For example, if you're married to a US citizen, you got your green card through marriage, then the total number of years will be 3 years. And also it requires you to live in US continuously for the 5 years preceding your application. And for example, you would not want it to spend over a year outside the United States. And then also the other requirements, you have been physically present in the US for at least half of the 5 years before filing your application. And also you need to have good moral character, which is something we kind of talked about a little bit. So let's just say if you fail to pay your taxes, if you fail to pay your child support, or you committed any crimes like gambling, other kind of crimes, it does have impact on your good moral character that needs to be dealt with. So I would certainly suggest that if you have any of the issues that potentially could be a concern, you should certainly bring them up to you during the consultation with the attorney, so you can anticipate how to prepare or with those potential issues that can have a bad impact on your citizenship petition. Language sufficiency, yes, you are required to take a civil test. Generally speaking, it's 100 questions, but there are also exceptions for elderlies. And they can have a much easier test to take, the civic part, which is instead of 100 questions, they just need to study 20 questions. And also there's certain age, when you reach certain age and the number of years being here on a green card, you're also having the opportunity to bring an interpreter. So there's various options for that, but generally speaking, language sufficiency is required for naturalization. So next slide.
Okay, thank you, Chelsea. Take a deep breath. You've been talking a lot. So thank you very much. We're going to move into the tax part, but I'd like to encourage you all to submit your questions in the Q&A part in the that function on your screen, so that we can review them and answer them either as we go along, as we're able to, or at the very end. Thank you. Okay, Peter, you're up. Next slide.
All right. Thank you very much. Now that Lucy and Chelsea have told you how to get to the US, I'm going to go over the cost of being here. Next slide. So being a US tax resident, you don't need to necessarily have a green card or be a citizen. Simply physically being in the US for a substantial period of time is enough to be a tax resident of the US, and therefore subject to tax on your worldwide income. And you may have heard of this before, the substantial presence test. Basically, if you're in the US for 31 days of the current year and 183 days over a period of time, a 3-year, according to a formula, then you are considered substantially present in the US, and so therefore a tax resident, and so you're taxed on your worldwide income for that year. In addition to the substantial presence test, you can have your green card, your lawful permanent resident status. That also makes you a US tax resident, and of course, if you're a citizen. There are certain elections you can make to be a tax resident as well, even if you don't meet those 3 different tests. Next slide. So the substantial presence test, basically, we look back over we look at the current year and the prior 2 years. And if, according to the formula where we count all the days in the current year, 1/3 of the days in the year prior, and 1/6 of the days in the year prior to that, if we add all that up and we're at 183 days or more, then you're considered substantially present, and so therefore US tax resident. And you'll see, according to the example here, if you're in the US 120 days every year, then just by doing the math, you cannot be substantially present. in any of the given years. And so that's kind of the magic number there is 120 days. Be in the US physically no more than 120 days every year, and you'll be fine. If you are considerably substantially present, though, and therefore U.S. tax resident, there are certain exceptions to still being a U.S. tax resident. One is a treaty. The U.S. has many income tax treaties with a lot of different countries. And if you are a tax resident of a treaty country, then we can rely upon the treaty to call you a non-resident of the U.S., even though under the default rules, you may be considered a U.S. tax resident. Other than a treaty, there is something called the closer connection exception, where if, let's say, for under the substantial presence test, you're a U.S. tax resident, but for the current year, you are in the U.S. for less than 182 days, then we can rely upon what's known as the closer connection exception. And so if you have a tax home in a foreign country and your family's there, and you have basically a laundry list of other things where you're connected to a different country for that year, then despite being substantially present in the US, according to the formula, we can still call you a non-resident for that year. Next slide. So before you get to the US and have to deal with all of the US tax laws, there are certain planning opportunities you should look into, pre-arrival planning. And so if you're a foreign person with a foreign corporation and you got income being generated in these various different buckets, that's all well and good. But when you get to the US, there may be some substantial US tax effects with regard to your holdings. For example, if you own more than 50% of a non-US corporation, then when you get to the US, that corporation will now be considered a CFC, controlled foreign corporation. In and of itself, that may not be an issue other than additional reporting, but if that company is generating what is known as subpart F income, then even though you are not receiving any distributions at all from that corporation, you still may be taxed on the corporation's income. And that can be very punishing for certain individuals who are unaware they have no cash because they received nothing from the corporation, and yet they're still taxed on the income being generated by that corporation. And we can, if proper planning is done prior to arriving, prior to becoming a U.S. resident, we can either eliminate or mitigate those potential tax issues. And that's true for ownership in foreign companies, or if you are a beneficiary of a trust, or if you're thinking about engaging in estate planning, it's generally best to do it prior to arrival, setting up trusts prior to arrival. So basically, a lot of pre-arrival planning can be done with regard to these various assets held outside the US generally to minimize the US tax effects. Next slide. So when you do get to the US, there's a whole list of filings that have to be done with regard to your ownership in assets outside the US, whether they're your beneficiary of a trust, or whether you're considered as the quote unquote owner of a trust, or if you're owning partnerships or corporations, all outside the US. There's all these different forms you need to file, and there are substantial penalties for non-filing, as you can see here. Next slide. So let's say you get to the US and you're really tired of all of the taxes that you're paying and all of the forms you're filing with the IRS. There is an opportunity to leave the US, and depending upon your status as a green card holder or potentially a citizen, there may be a tax to pay on your way out. And so there is the exit tax here for those who leave the US. In the case of a green card holder, if you are a green card holder for more than 7 years and you've been filing resident returns with the US, then in your 8th year, you will be considered a quote unquote long-term green card holder. And so if you relinquish your green card following the 8 years, then you will be subject to the exit tax provided that your assets, your income exceed the threshold. Currently, the threshold for assets is 2 million. And if your income is sufficient enough where you're generating on average an income tax liability of currently $178,000, then you will have surpassed both one or both thresholds, and so therefore the exit tax regime would apply. For green card holders, there's a good amount of planning that can be done to mitigate or even eliminate the exit tax. For citizens, there are options as well, but they are generally less effective and less available to them. Next slide. Next one. So with regard, so when you become a U.S. tax resident, it can be for both income tax purposes, based on your green card or based on being substantially present in the U.S. For estate and gift tax purposes, however, the definition of resident is different. Sure, physical presence in the U.S. is important, green card is important, but those in and of itself, the substantial presence test, they are not definitive as to whether you are a resident of the U.S. or not for estate and gift tax purposes. Instead, for estate and gift tax purposes, we look at what is your domicile. And domicile is very close to what your residence is, but it's a little bit more fact intensive. It's looking at things like where is your family, where's your home, where's your business, basically where's your life. Have you shifted your life from a foreign country to the US? And when we're looking at those various factors, if your domicile has shifted to the US, then you are a tax resident of the US for estate and gift tax purposes. If balancing those different criteria, we see that your domicile hasn't shifted, it's still possible then that you are a resident of the US for income tax purposes, but not for estate and gift tax purposes. And that differentiation can be capitalized on from a planning perspective. We can have situations where a transfer of assets for gift purposes can be completely free of estate and gift, U.S. estate and gift tax purposes, estate and gift taxes for income tax planning. And that's something we have engaged in quite a bit, where we can leverage basically the difference between the definition of U.S. tax resident for income tax purposes as opposed to estate and gift tax purposes. And that difference can be capitalized on not just coming to the U.S., but also leaving the U.S. as well. Generally, though, for estate tax, the U.S. estate tax is applicable to U.S. residents to the extent that their worldwide assets exceed, currently anyway, a little over $12 million. For non-residents of the U.S., the estate and gift tax still applies to them, but only to the extent that they have U.S. cited assets. And I'll go over briefly what some assets are considered U.S. cited. In addition to the lifetime exemption of currently 12 million, there's the annual exclusion. Basically, anyone can gift to anyone else up to currently $16,000, no tax returns, no gift taxes, nothing at all. For transfers between spouses, if we're transferring to a U.S. citizen spouse, then it's an unlimited amount. No gift taxes, no gift tax filing. But if it's to a non-citizen spouse, then we basically are limited to an annual exclusion, which is much higher than the $16,000. It's currently $164,000, and that number is indexed for inflation. Beyond the $164,000, any other transfers to a non-citizen spouse will be subject to U.S. gift taxes, or you'd be utilizing some of the lifetime exemption. Next slide. So for a resident, again, only subject to estate taxes on US cited assets. And if our assets are exceeding an exemption of just $60,000, then we're looking at estate taxes. And at that rate, we're looking at a tax rate of about 20%, riding all the way up to about 40%. So it's very important for non-residents to the US to minimize their holdings of US assets. Next slide. So here's a comparison chart, very briefly, between a tax resident and a non-resident. For the annual exclusion, we're looking at worldwide assets for a resident. They can gift, again, $16,000, no taxes, no return. Anything in excess of that is going to be utilizing their exemption of currently a little over 12 million. And anything in excess of the exemption amount is now at 40% tax. For non-residents, for gift purposes, they have no exemption at all. They're limited to just their $16,000 annual exclusion, and anything above runs from 20 to 40% tax. For state tax purposes, again, same thing. Got $12 million exemption for the US resident, and only $60,000 for the non-resident. But again, the non-resident is subject to US taxes only on US cited assets. Next slide. So for what's the US cited asset? Cash in US banks. Yes, for gift tax purposes. So if you are non-resident and you have a bank account in the US and you make a gift of cash to someone else from that US account, you're going to be subject to US gift taxes. If you die instead holding that account, estate taxes shouldn't apply. What you should be very careful though of is what type of account are you holding? If it's a regular bank account, savings account, you're probably safe in that regard. If instead you got a brokerage account where your cash is really in a money market account, now we're really looking at the money market account more like a stock. And so if it's a stock in a US company, yes, gifting the stock, no problem. It's an intangible asset, you're not going to be subject to gift taxes. If instead you die holding a US stock or a money market, now you're going to be subject to estate taxes to the extent that that amount exceeds the exemption. Again, for non-residents, that's $60,000. For the other assets here, it's relatively straightforward. Obviously, real property in the US is US cited asset. Tangible property located in the US cited asset. For partnerships, is a bit of a gray area. For partnerships, if the business of the partnership is in the US, likely it'll be treated as a US cited asset. If the business is really outside the US, then there's a potential to be treated as a non-US asset, even if it's a quote unquote US partnership. Next slide. So for distributions to a US resident who is a beneficiary of a trust, that can be pretty tricky. When you're a US resident and you're receiving a distribution from a trust outside the US that perhaps your parents set up, then you will be subject to a tax regime that can be rather complex. And that depends basically on what type of trust are we talking about. Is it what's known as a grantor trust as to a foreign person? Generally, in those cases, you're not going to be subject to any income taxes. The grantor trust status for foreign trust, though, is very limited. More often is the case, you'll see that you'll have a US resident who is a beneficiary of a non-grantor trust. And in that instance, when the US resident receives a distribution from a foreign non-grantor trust, they are, one, subject to income taxes on the distribution, and what type of tax is being paid on that distribution. We now need to look at the character of the income. If it's capital gain, generally you'll get capital gain treatment at reduced rates. But we need to go a bit further than that, in that we need to analyze the trust's income, both on the current year and in prior years. So if a U.S. beneficiary receives a distribution excuse me, that is at or below the trust's current year income, then we can follow the character of the income and tax it accordingly. If what the U.S. beneficiary is receiving exceeds the trust's current year income, now the beneficiary has received what is known as accumulated income. And to the extent that a beneficiary has received accumulated income from a foreign trust, we're now looking at yet another tax called throwback tax, where basically the U.S. beneficiary pays tax at ordinary rates on the distribution, no matter the character of the income. And they're paying on top of that something called a throwback tax, which is essentially an interest charge, but it gets a little bit more complex than that. And depending upon how long the income has been accumulating in the foreign trust, the U.S. beneficiary can be subject to a rather punishing tax when you add them all up. Distributions from a foreign trust don't necessarily have to be actual distributions of cash. They can simply be utilizing property of the trust or receiving a loan from the foreign trust. So we need to be very careful as to what is the beneficiary receiving, how are they benefiting. Next slide. And so with regard to foreign trust, there's a good deal of planning opportunity. In the US, when we're talking about estate tax planning, very often is the case, you'll run into a situation where setting up what's known as an intentionally defective grantor trust is very effective from an estate tax point of view. And that can also be utilized here for when we're talking about a foreign trust, where we're intentionally getting into a grantor trust where a U.S. person is being subject to taxes on the trust income. But we're cognizant of that, but that's the actual goal of the trust, so that we can minimize the estate taxes by reducing the grantor's estate over time. But we can often in this case, though, we run into trusts where they are non-grantor trusts, and if we have a U.S. person who is setting up this foreign trust, foreign non-grantor trust, we need to be very careful about what assets are being transferred to that trust, because there could be a situation where you have a U.S. person transferring an appreciated asset to a foreign non-grantor trust, and that's basically treated as a sale. And so now we've got income taxes to be concerned about. And so I know I rushed through that very quickly. We're a bit out of time right now, but I guess we're ready to take any questions. Thank you very much.